Committee Room 30, signed. 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 Committee Room 30, sound. 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 Committee Room 30.
So we have a quorum. So I'm going to call the meeting to order, everybody, and declare it open to the public. I want to welcome you all to the 79th meeting of the Committee for Justice and advise you all that the committee meeting will be recorded and broadcast throughout Parliament buildings as well as online. Members and everyone in the public gallery is welcome to use their mobile devices as long as they're in airplane mode and all devices are muted. It's proposed that initially we'll get an oral evidence session from the PPS and then with the PSNI, and both of those briefings are going to be recorded by Hansard if members are happy with that. Yeah, and I take that as agreement. I want to remind members that you're obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence your approach to the matter under consideration. So if any members have interests to declare in relation to today's business or anything relevant to the committee. Connie?
Yeah, on items 4 and 5, just given the topics we'll be discussing and the PSNI and the PPS are coming in to present evidence, I think it's important I declare my fiancé, who's also an Alliance Party councillor, was a victim of a hate crime. That case was investigated by the PSNI and the case is currently sitting with the PPS. So I think it's important to put that on the record before we begin.
Thanks, Connie, and I think probably the entire committee will express solidarity to him for that. Do any other members have any other interests that they want to declare at this point? Just the membership of the Access to Justice APG that I think most members are on. So our first agenda item is apologies, and we've received apologies today from Paul Frew, the chair, which is why I am here in his place. Do we have any other apologies at this moment? We don't have Morris or Aoife attending yet, so I don't know. They're potentially just late. I haven't received apologies from either of them. So as they approach, we'll update the record to reflect that. And Ciara Ferguson is attending the meeting virtually today. So the second agenda item are the draft minutes. The draft minutes of the meeting held on Thursday, the 11th of June, are at pages 5 to 14 of the meeting pack. Are members content that the minutes are a true reflection of the proceedings of the meeting on the 11th of June?
Agreed.
Agreed, and I'll be able to sign the minutes. Happy days. And our third agenda item is matters arising. So at last week's meeting, we agreed to forward the list of issues raised in evidence that are not in the sentencing bill to the Department for information on any work that they might be undertaking on these issues. Johnny's Law was inadvertently missed from the list, but was included in the letter that was issued to the department earlier this week. Does anyone else have anything else that they would like to forward to the department at this stage? No? Okay. Agenda item 4. We have got our first briefing, so I want to refer members to pages 16 to 36 of the meeting pack. We're receiving oral evidence today from the Public Prosecution Service with regards to the sentencing bill, and I want to welcome Michael Agnew, the Deputy Director of Public Prosecutions, Richard Scullion, the Head of Policy and Information, and Cathy McGeal, Principal Public Prosecutor, Policy and Information Unit. So I want to thank you all for taking the time to present to the committee today, welcome you all, and invite you to make any opening statement that you might want to.
Thank you very much, Deputy Chair. My name is Michael Agnew and I'm the Deputy Director, as you've just indicated. I'm here today with Dr. Richard Scullion, who leads our Policy and Information Unit, and also Miss Cathy McGeal, who is a Principal Public Prosecutor within that unit. So we're grateful to the committee for the opportunity to contribute to your scrutiny of the sentencing bill, which is clearly a substantial and significant piece of legislation. The bill covers several important areas of sentencing law. We are aware that the committee has been discussing issues involving difficult policy judgments, particularly around the topic of hate crime. We thought that perhaps we could add greatest value by providing some observations relating to the operational consequences of certain parts of the bill. And to that end, I propose to focus my opening remarks on, firstly, the provisions relating to life sentences for murder and the determination of tariffs. Secondly, the duty to follow sentencing guidance. And thirdly, the proposed statutory aggravator that is based on vulnerability. So taking each briefly in turn. So the determination of tariffs in murder cases. The committee will have our addendum submission, which sets out the current approach to the setting of tariffs as established through judgments of the Court of Appeal, and which explains how the bill would represent, in our view, a fairly significant change. We've highlighted how several of the factors listed in paragraph 1.2 of the proposed Schedule 1A are currently associated with a starting point of 15 or 16 years. Under the bill, each would instead normally attract a starting point of 20 years. In our view, this has the potential to lead to a significant increase in the tariffs that the courts will set in murder cases. We haven't identified any clear recognition in the material published to date that the bill would have this effect, and so we therefore considered it important to ensure that the committee fully understood this so that it could consider whether such an outcome is desirable. We've also identified certain factors, specifically those at subparagraphs J and K, which do not feature in the current law, have no comparator in England and Wales, and where views may reasonably differ as to whether they properly elevate the seriousness of a murder such that an enhanced starting point is appropriate. We've noted that it may make more sense for factors J and K to be combined into a single factor, as is the approach in England and Wales. And under the bill as drafted, the existence of a personal connection between offender and victim would, without more, normally lead to a 20-year starting point. It's important to understand that the definition of a personal connection is very broad and includes any members of the same family. So secondly, the duty to follow sentencing guidance. The PPS recognises the importance of improving transparency and public confidence in sentencing. We also recognise that the existence of clear sentencing guidance followed consistently can assist in achieving that objective. Clause 2 requires the court to identify any sentencing guidance which is relevant to the offender's case and explain how it discharged its duty to follow that guidance. Sentencing guidance is defined at Clause 2(4). It includes cases that are identified as guideline cases, as well as those that are not, but which contain guidance which is relevant to the court's sentencing function. There is a similar statutory duty in England and Wales to follow sentencing guidance, but the duty in that jurisdiction does not extend to the identification of the relevant guidance and an explanation as to how the court is discharging the duty to follow such guidance. Furthermore, in England and Wales, sentencing operates within a structured framework of formal guidelines issued by the Sentencing Council. This reduces reliance on individual authorities, by that I mean cases, previous cases, and tends to support shorter and more accessible sentencing remarks. In the absence of an equivalent framework in this jurisdiction, it seems to us that there is a risk that the provision may have the opposite of the intended effect. In particular, it may encourage increased citation of authority, leading to longer sentencing remarks and potentially creating additional grounds of appeal as to what guidance is relevant in any given case. Given the way in which sentencing guidance has developed in this jurisdiction, some uncertainty as to relevance is likely to persist. It may therefore be helpful to consider what further steps might be taken to give judges and practitioners greater certainty as to what judgments are properly to be considered guideline judgments. And finally, and this is a point that has occurred to us just recently and subsequent to our written submission, it appears that the provisions imposing duties upon the court in relation to following sentencing guidance apply both in the Crown Court and the Magistrates' Court. Further, we understand that the current Magistrates' Court sentencing guidelines are issued by the Lady Chief Justice's sentencing group and therefore fall within the statutory definition of sentencing guidance. That being the case, the Magistrates' Court would be required in every case to identify the relevant guidance and explain how it is being followed. Sentences are currently passed without such explanation in the vast majority of cases, and this change will dramatically alter sentencing practice in the Magistrates' Court. It could have a significant impact on the efficiency of those courts. And then the third key area that we wish to address is the aggravation by reason of vulnerability. We understand that this provision developed from a proposal for an age-based aggravator but has evolved into a broader statutory aggravator based on vulnerability. Vulnerability is already an important factor in sentencing and is routinely taken into account by the courts. The issue is therefore not its importance, but whether a statutory aggravator is a practical and effective way of addressing it. We see a number of potential difficulties. First, the proposed definition is very broad, particularly the inclusion of vulnerability arising for any other reason. This may create some uncertainty for investigators and prosecutors as to when the aggravator should be applied. It appears that if the prosecution does not apply the vulnerability aggravator to a charge at the outset of a case, the court may be prevented from taking vulnerability into account when sentencing. This would be extremely unfortunate, particularly in a case where the nature or extent of the vulnerability only becomes apparent in the course of the proceedings. Second, vulnerability is inherently subjective. Victims may not identify as vulnerable or may disagree with decisions taken by the prosecution as to whether to apply the aggravator, which may give rise to some potential distress. Third, unlike many existing statutory aggravators, vulnerability may depend on matters that are removed from the circumstances of the offence and which may be complex to prove by evidence. Where it is formally relied upon, this may raise disclosure issues, particularly where it involves personal information about the victim with the potential for that to be intrusive. Fourth, the attachment of a statutory aggravator is likely to make cases more difficult to resolve. Experience suggests that defendants are less likely to plead guilty where an aggravator is an issue, which may lead to more contested hearings. There is the real potential for multiple aggravators to apply in certain cases, and this would only compound the potential problems. And fifth, the breadth of definition risks limiting the practical value of the aggravator. It may not be clear what the presence of such an aggravator signifies in any given case. And sixth, while the definition is broad, the statutory aggravator appears to create thresholds that may be difficult to satisfy. For example, it requires significant impairment of the victim's ability to protect themselves. It also requires that the prosecution prove that the defendant knew or ought to have known of the vulnerability. There is considerable flexibility in how courts currently approach vulnerability when dealing with it as an aggravating factor for the purpose of sentence. We would be concerned that the introduction of a statutory aggravator in this form may add complexity and create a number of operational problems without necessarily improving clarity or outcomes. If I may conclude with three brief observations on other aspects of the bill. First, we support the extension of the unduly lenient sentence scheme to all Crown Court sentences. There are several reasons why the extension of this power to the Magistrates' Court would not, in our view, be appropriate. These include the limited scope for any successful referral from the Magistrates' Court, having regard to the high threshold to achieve, the potential resource implications, and the fact that the Magistrates' Court is a court of summary jurisdiction that is focused on speed and efficiency. It is not a court of record. Second, we support the move to the statutory aggravator for offences motivated by hostility. The existing enhanced sentencing model has not operated as effectively as intended, and we consider that a different approach is now justified. And finally, we note the various provisions in relation to public sector workers and the broad definition of a public sector worker as contained in the bill. We understand that there is some concern as to whether the definition is potentially too wide, and the aggravator would be better targeted at specified public workers where there's evidence of a particular concern. From an operational perspective, there could be cases in which the application of the aggravator is unclear, although this is much less likely to occur than would be the case for the vulnerability aggravator. Some consideration should also be given as to how such offences are recorded on the criminal record, so as to allow the identification of serial offenders, for example, offenders with a history of assaulting police or other types of public worker. So we hope those comments are of some assistance to the committee, and we are happy to take questions.
Thanks very much, and I appreciate you coming, and also the briefing paper and the addendum that you provided. And I suppose I want to start with something that you touched on in the addendum, and that's around it's point 14 on page 6 of the addendum, where you talked about the tariffs for murder cases.
Yeah.
And your concern around your initial understanding and your understanding of what had been presented to the committee compared to what is now been presented. You think, I'm reading,
Yeah.
that you think that there's substantial difference between what was initially presented by the department to what is now been?
No, I suppose what I'd understood the purpose of the bill as far as life sentences to be was really to place the existing regime to a large extent in statutory form so that there was greater transparency around that. And I think the explanatory memorandum and so on explains that objective. It refers to the Whitla case, which actually dispensed with, or took the new normal starting point as 15 or 16 years and not 12 years. And really, that was really the objective of doing it. And it referred to the fact that the factors that are listed in the bill are taken from existing case law. Now, I may have assumed, sort of incorrectly, that it was intending to mirror the existing case law in terms of where the threshold or where the starting points may be. But it was only when looking at it a little bit more closely and comparing side by side the bill with the existing case law that I'd identified that I think maybe six of the 11 factors that would previously have given a starting point of 15 or 16 years are now given a starting point of 20 years. So it may well be, and since then I have gone back over some of the materials to see if I could identify, have I missed something there, and maybe the committee knows something or can point to something that I haven't. But I didn't identify anything that had indicated that, I suppose, a policy objective of the bill was to address any issue with the sentences that the courts are imposing in murder cases, and that there was an intention to raise murder cases in many years, or in many situations, by maybe 5 or 6 years.
And further to that then, do you think that there is a problem with the existing, that where you're talking about the starting point of 15, do you feel it needs that policy change?
No, and as an organisation we tend to remain fairly neutral on sentencing levels, and because there are sort of value judgments to be made that are to be made by the Assembly and the Executive. But I hadn't heard in any of the discussion, hadn't picked up anything that there was a concern, and the court will be familiar with some of the tariffs that have been set in murder cases in recent months and years. One very recently at 31 years, and everyone knows that case. And other cases that are regularly in the 20s or the 30s. And I think, in fact, the Assembly research paper would show that the average tariff over the last, since 2020, varies between 17 years and 21 years. And obviously very conscious of the issues around violence against women and girls and domestic violence. But also the Court of Appeal is clearly very conscious of those issues as well, and has sought to reflect the way society has moved on and how it's sentencing in those cases. And we regularly see sentences of over 20 years. When I say sentence, it's a life sentence, but the tariff is 20 years and more in domestic violence cases. So I hadn't identified any concern around the levels that were being set. But then within the bill, I think the likely effect of the bill is that we will see that tariffs are notably higher as a result of it.
And have you had discussions with the department about this?
Yes. So whenever I suppose I'd done my own analysis of it, I ran that past my colleagues in the department to check that, and I think they confirmed that in fact it was our intent to increase the starting point in a number of situations to reflect societal changes. But a number of the matters that are moved from 15 years to 20 years are maybe not things in which it's obvious that society has changed. They're things like a murder for gain, or a murder to obstruct the ends of justice, those types of things. So found it not absolutely clear the connection between maybe the likes of
I don't want to draw you into giving it, but I'm getting the sense from you that you maybe don't think that policy change was necessary.
Well, it's, as I say, it's really a matter for others to decide whether that. I wasn't aware of any concern around the sentences that the Court of Appeal has been passing in murder cases.
Okay. No, that's fine. Thanks very much. I'm going to move on to members. So I've got Doug, first of all.
Thank you, Chair. Michael, thank you very much for your brief. Always insightful as ever. I've only got 2 points really, and the first one deals with Clause 2, which is the imposed duty to follow guidance relevant to the case when sentencing. You talked about the Sentencing Council. You will know that I'm an advocate of a Sentencing Council for Northern Ireland. Could I ask you maybe just to explain what the benefits then could well be if we had that Sentencing Council, which could help with sentencing and better understanding, and particularly public confidence?
Yeah, and I'm aware that you're an advocate for it, and I'm also aware that there have been previous consultations run by the department on it, and there are different views about it. And I'm aware that the senior judiciary maybe isn't so strongly supportive of it. And I'm also aware that there are cost implications of something like that, and some of the discussion has been whether a council like that is practical in a jurisdiction of this size. From my own point of view, I think it is a lot easier for a member of the public to pick up a sentencing guideline and read it and see how the courts will sentence certain types of cases, and to try to work that out from a lengthy legal judgment or a collection of legal judgments. And so I think it potentially enhances transparency. And I think we've seen some examples in England and Wales of sentences. I mean, I could think of one I remember the Hugh Edwards case, and I think there was a suspended sentence on that, and maybe initially there was a sort of a very strong reaction to that, but then quickly legal commentators were on explaining how the court got to that by reference to the relevant sentencing guideline, and I think people could see quite quickly, well, this isn't unusual or this isn't exceptional, and there actually is a clear route to how the court got there. And I think with a guideline, I think it's easier for the court to explain to the victim, to the member of the public, really quite quickly how it got there. I mean, there's an English Court of Appeal decision which discourages courts from oversighting other authorities, and just says, just get to the chase. Here's a guideline, apply it, and with a degree of flexibility, of course, but show us how you got to the end point. And I think a guideline can facilitate that potentially better than a guideline judgment or a series of guideline judgments.
Yeah, and I suppose just on that, and I absolutely get the point you make, because I listened to the sentencing of Alex Ruda-Cabana, and wherever he was screaming for a whole life sentence with that, whenever we listened to what the judge said, you actually understood why he didn't give a whole life sentence in regards to that. But if we were to go down a sentencing council here in Northern Ireland, it doesn't have to replicate what they have in England and Wales, or even what they have similar in Scotland, or even what they have in the Republic of Ireland. But I take it that the Public Prosecution Service would have the ability to influence something that would be able to work bespoke here for Northern Ireland.
Yeah, well, I suppose the membership of the council would be something that is open to debate, and also how the council goes about its work and who the council must consult with. Because we've got different models. We have the model in England and Wales. I think Scotland has one, and the Republic of Ireland has one as well. And they're all a little bit different, but they're generally made up of legal members and lay members, to bring a slightly broader perspective on it. And I can't recall, it may well be that the Director of Public Prosecutions in England and Wales is on there, but I don't hold me to that. But certainly either through membership or through consultation, us potentially being a listed consultee, we would have an opportunity to provide some input. Just one other point on transparency and public understanding. The Sentencing Council can provide guidelines not just on the appropriate sentences in individual cases, but on the sentencing process, and also aspects of the process like guilty pleas and discount for early guilty pleas, which is another area that I know that you're interested in. So they can potentially provide an authoritative document that takes a member of the public through the sentencing process generally from start to finish in a clear, sort of accessible way. So it can add the transparency in that way as well.
Thank you. I'll move on to the second point, because having walked in the same direction as you on that point, I'm now about to walk in an opposite direction on the issue around clause 20 to 23, which is the unduly lenient sentence and the right of appeal, because you believe that we stick with just the Crown Courts, and I know there's been a few options there, and you say stick where it is, speed and efficiency. But again, I'm back to this issue of confidence, because we're not able to appeal within the Magistrates' Court, and without looking at that as a whole and saying we should be able to appeal everything in the Magistrates' Court. Can I ask you then what your view would then be in regards to hybrid cases? So hybrid cases that could be tried in either the Crown Court or the Magistrates' Court. And if they're decided to be tried in the Magistrates' Court, you then can't appeal them.
That's right.
And some of those are sexual assault, for example. Non-fatal strangulation is a hybrid case. Upskirting and downblousing is a hybrid case. And where somebody goes to a Crown Court and gets 3 months for that, and we can challenge it. If they go to the magistrate and gets 3 months for that same thing, we can't challenge it. So is there a place that actually, even though you're saying no, we shouldn't go into the Crown Court, for hybrid cases, do you think we should?
No, I don't. Because if hybrid cases, if they're prosecuted in the Magistrates' Court, you're going to be dealing with the lower end. So a non-fatal strangulation, I think we're seeing fewer and fewer of those in the Magistrates' Court now, and more will be prosecuted in the Crown Court. But I think that mechanism, that safety net there, is really to deal with the more serious cases generally. And I'm not diminishing the seriousness of cases in the Magistrates' Court, but one has to draw a line somewhere. And I think the difference between the Crown Court jurisdiction and the Magistrates' Court jurisdiction is an appropriate place to draw the line. I would also note that the extension of the unduly lenient scheme to all Crown Court cases, whether they be indictable only or hybrid, is further than our neighbouring jurisdictions have gone. And in England and Wales, they're kind of in the same position where we were, which is indictable only and certain specified hybrids. And I think they've had a consultation on sentencing recently, and I think they are considering adding a few more hybrid offences, but not going as far as we are going in this. So as far as this jurisdiction is concerned, we are, I suppose, offering, we have a more generous or a broader scheme for unduly lenient than we will elsewhere. The other difficulty with, I mentioned about the Magistrates' Court not being a court of record. The way the sentencing works in the Magistrates' Court and the way it works in the Crown Court is really quite different. With summary justice, it's a lot more informal. In the Crown Court, everything is laid out on paper a lot more. There's citation of authorities, detailed written submissions. The judge often will reserve judgment, give a carefully reasoned sentencing judgment, and then all of that material can be available for the Court of Appeal to analyse very carefully how the judgment was arrived at and whether there's a gross error of law in it or not. The Magistrates' Court doesn't really facilitate that because the proceedings aren't conducted in that way, and it's not a court of record.
And if you put it like that, then Michael, my argument back to you is, then that's going to damage confidence with the public. If you're telling me that in the Magistrates' Court we don't go to the same level that we need to do in the Crown Court, and the very reason that we do appeal against unduly lenient sentences because we think the judge has made a mistake.
Yeah. Well,
so if we think the judge has made a mistake in a Magistrates' Court, it's the same principle, but we don't have the recourse to do that. So the whole remit of why we do appeals is because we think somebody's got something wrong. But in this case here, you can get something wrong in a Magistrates' Court and there's nothing we can do about that.
It's not an appeal. An unduly lenient reference is not an appeal, and it's different to a defence appeal. And I don't mean that in a technical way. I also mean it in terms of the threshold that's involved. Okay. And it is really there to, and it's not just any mistake, it's really there to correct really gross errors that give rise to significant public concern. And I think that, I don't say that can't happen in the Magistrates' Court, but it's a lot more likely to happen, where there is a public interest in correcting something that has gone very badly wrong in a more serious case in the Crown Court than there is in the Magistrates' Court. So it's really just about proportionality. I mean,
look, I've written to you often enough about unduly lenient sentences, and I've got to be honest, I always get a really fulsome reply, and it explains it very, very well. I have no issue with that on what you do, so that's not really what I'm saying. But I know that I'm following 2 cases at the minute of non-fatal strangulation. Both are going through the Magistrates' Court. Right. Yeah. But we had a discussion about this, and that discussion was that most of these should be going through the Crown Court now, because the threshold increased from 2 years to 3 years. For sentencing. Yeah,
and the vast majority of them are going through the
but I'm still following 2 cases which aren't. But look, you've answered the question. That's very good. Thank you very much.
All right, Conor or Patsy next. Sorry.
Thanks very much for your presentation. I'm sort of getting back there to the whole issue of the sentencing guidance and how that's done, because regularly we see cases coming up that you're saying, well, how come that's so on the face of it lenient compared to somebody else who maybe got twice the sentence for a similar type of offence. Now, just can you talk me through how the mechanism of any consistency approach might work by way of guidance to do that, please?
Under the current?
No, under what might evolve.
Well, I think what is potentially set out in the bill here, which obviously doesn't include the idea of a sentencing council at the minute. So really what the court is being required to do is to follow any guideline judgments that may have issued from the Court of Appeal, or any that are identified as such, or any that aren't identified as such but provide relevant guidance to the particular case before the court. That's not that different to what happens at the moment, really. When the Crown Court is sentencing a case, there's a duty on both parties to present to the court anything that is relevant by way of previous authorities. And so that will continue to take place, and the court will, usually in its sentencing remarks, refer to some extent to those previous authorities. Now, in certain types of areas of law or types of offending, there aren't maybe any guideline cases, and it becomes a little bit trickier, and the court has less of a steer from the Court of Appeal.
Well, that's where you're taking me. How can that be done better?
The way the system works at the minute is the Court of Appeal waits for an appropriate opportunity for a case to come before it. and it will consider whether this case provides an appropriate vehicle to provide some guidance for future cases. And I know that the department is looking, maybe was looking at this stage, but maybe into its next review as to whether there's anything that can be done to facilitate the Court of Appeal more frequently giving guideline judgments, or not necessarily having to wait for the appropriate case to arrive before it in order to do so. But again, I think that there's a fundamental difference between the Court of Appeal giving a guideline judgment, which will potentially provide a bit of a framework in terms of some of the different types of cases and where the starting points might be, and a guideline that is produced by a sentencing counsel, which will tend to be more comprehensive in terms of the range of factors and considerations that can arise.
So from where, if I'm picking you up right, you can depend on a Court of Appeal judgment, which might occur and might not occur. You might have quite a considerable wait for that.
Yes. Or
Or you can depend on, say for example, the Court of Appeal itself taking the initiative and issuing its own form of guidelines. Now,
it can't do that. It can't do that.
well, that's my point.
Yeah.
So therefore, there isn't an alternative to a case coming before it.
Not at the moment.
Not at the moment. So that brings me on, if they can't do that and won't do that, and there's no catalyst in particular for that, other than a case coming before them, how do we get to the point then of a sentencing council?
Well, the sentencing council is just a completely separate body that would be created.
No, I get that,
Yeah.
but legislatively, are you well, not suggesting, are you saying that a lever or an actionable body or a methodology of ensuring that there is consistency of sentencing would be a sentencing council?
Yeah, that would be one of the main arguments that is put forward for a
Yes.
sentencing council.
That's grand, thank you for that. Now, the one other thing, in one of your remarks there, you referred to the magistrates' courts, and you mentioned around the sentencing issue, and that could have a significant impact on the function of those courts. Can you expand a wee bit on that for me?
So, I don't know if you've been in the magistrates' court recently, but justice is dispensed necessarily with some speed, and the sentencing that takes place at the minute, there are magistrates' court sentencing guidelines, and they're quite detailed, and they give broad ranges for different types of offences. But really, most of the time, the district judge dealing with the summary case is very familiar with these types of cases, very familiar with the types of sentences that might be appropriate, and will announce in fairly summary terms what the outcome of the case is.
Yes.
My understanding of the provision in the bill is that there would then be a duty on the district judge not just to follow the sentencing guidelines that exist in the background, but to state in open court that they're doing so, and explain how they are discharging their duty to apply those guidelines. So it seems to me that that is adding layers of process and potentially
I'm going to have to stop you there just a minute, please. Why should that prove to add an existing layer of bureaucracy, whatever it is, to a judge? If the judge can't explain what his rationale or her rationale is for arriving at their determination, then we have a bigger problem.
I think in the vast majority of magistrates' court cases, they're dealing with speeding offences, or it's assault on police and so on, and they're given a fine or maybe suspended sentence or whatever, and the sentencing remarks will generally be fairly brief. But if they're
Which judge?
but from my experience, anyway, but it's not that there wouldn't necessarily be some explanation. I mean, there may explain, but it would probably be more focused on the facts of the offence. And, they're looking maybe at a pre-sentence report and a criminal record. Those are the types of things, in light of your previous convictions for X and Y, those are the types of things that may feature more regularly in any sentencing remarks from a district judge. But referring to guidelines and a sort of slightly more formulaic or mechanistic approach of finding a pathway to an outcome through the mechanism of sentencing guidelines isn't something that happens at the minute, and it would be an additional aspect to process in the magistrates' court.
Oh well. Now, can I move on then, please, to the issue of, which is very topical at the moment, then, hate crimes, the aggravation scheme, and if we can maybe just deal with, because a number of those that may be quite, given the nature and makeup and composition of our health service, there might even be an overlap between the two. So could you take me, well, first thing is just in regard to hate crimes, especially we've had a heavy focus on race hate crimes this last while. as to how that could best be judged or done in such a way at the courts to send out a very clear message that hate crimes of any sort are despicable and awful, and but that the courts will lean very heavily on offenders of that type. Yep. If we could have that first, and then my second question is about the public workers, and probably if we could talk about the public workers, we'll maybe look at, are we talking public sector workers or public service workers? In my mind, because the latter then broadens it much wider in its definition as to where we go and what decisions might be taken by a judge in that circumstance, because public service could be, well, it could take you anywhere. Yeah. So it'd be helpful just if we could have a few insights to that, please.
Yeah, so it's clause, no, that's the wrong clause. Clause 33 of the bill, that is dealing with aggravation by hostility. And your question was, what can we do to increase public confidence in how sentencing deals with aggravation on the basis of hostility? And I suppose this is a good model in the sense that the offence will be labelled up front as aggravated by hostility. The current mechanism is a little bit more sort of nuanced in that the prosecutor, it's not on the face of the indictment or the charge, but the prosecutor would present the case as aggravated by hostility, and the judge would make a finding, and it should be an enhanced sentence, and it should be stated and should be recorded, but we know that hasn't been happening as well as it should have been. I think this is bringing more formality and hopefully a bit more rigour and more transparency to the whole process, so it'll be up front at the start. It's alleged really as an aggravator on the front of the indictment or the complaint. It's requiring the court to say that the offence is so aggravated, and then to say how the aggravation has affected the sentence. Okay, which should have been happening to some extent already, but hopefully, I think, whenever we've got a new provision where it is flagged up front in a more transparent way at the start, we will get better compliance with that. And the other thing that we will get is the aggravation recorded on somebody's criminal record as well, which doesn't happen at the minute.
Pardon me for interrupting, just Michael, but can I ask this last week, a lot of the aggravating factors in the build-up to the commission of a crime can be posts online. So I take it there that those posts, if they're attributable to an individual and that individual is responsible for, by way of either organisation or commitment or commission of a crime, that can be looked into very rigorously. How in fact their motivation is very, very obvious from what they have posted online.
Yeah, I mean, in certain circumstances, their motivation will just be obvious from the circumstances of the offence. In other cases, the online material or previous posting could support the evidence of motivation. And in some cases, the online posting could be standalone offending, of stirring up hatred. So all of that can absolutely be relevant, both to the aggravation and to any other offences. On the public sector worker, which is clause 37, it certainly is very broad as currently defined. So I think there may be 5 ways that I've identified in which it's really quite broad. It applies to workers who are either employed or engaged to, secondly, provide a service to the public, perform a public duty or deliver a public service. I don't, on your point, is it just public service workers? I think it appears to be.
No, I'm talking about you kind of specifically where this started out was, say, like people working in the health service, people who are police officers, people who are actually ambulance drivers or paramedics, the likes of that, and then it kind of grew and expanded a bit from there. So what I'm trying to suppose to get at is, how effective do you think that would be without specific designations of public sector / public service workers, or with a more loose definition of public service workers? I'm just trying to nail this down to see what's, in your opinion, the most effective way of securing a conviction.
I guess hopefully we will secure a conviction for the underlying offence in any event, if you like. I suppose this is about, there's an element of it is about labelling and signalling to the public. At the minute, it's very broad. So could potentially include somebody providing any service or goods to the public. Could be a delivery driver, could be anything. And I think it also, what it does is it repeals the existing offences that are specific to, or the assault offence. Repeals the existing assault on police and so on. So it's certainly making the offence much more generic. And I don't know, I imagine police who come in afterwards may have sort of some views about that as to whether that's a good thing. It's definitely, I mean, I don't really want to advocate for a particular approach to this, because we have had some engagement with people who are providing various different types of public service, and one can see the challenges that they face and why one might wish to expand the scope of those who receive this particular type of protection. But I suppose the other point that I would make is, by excluding certain workers from this, we're not seeking to downplay the impact of the offences against those. The law has for many years distinguished between fire and rescue officers, police officers and so on, in terms of having a specific offence, because I think my understanding of the rationale is really they are assuming particular risks on behalf of the public that maybe a lot of other public service workers aren't. I think when you look at the murder tariffs, a distinction is made between police, fire officers and certain other prison officers and others. So there are different approaches to it. And ultimately it'll be for the Assembly to decide whether or not the offence should be broadened in the way that is currently proposed.
Okay, thank you. Thanks, Chair.
Thanks, Patsy. Connie?
Yeah, thank you all for coming in today. And I think just following on from what Patsy was saying around hate crime, something I'm quite interested in was last week we heard quite clearly from the Northern Ireland Human Rights Commission that the legislation needed a definition of hate crime. And I just wanted to know what your opinion of that was, the PPS, and do you think that's something that would strengthen the legislation?
I might pass, but I suppose there are two things to distinguish between here. There's hate crime and offences that are aggravated by hostility. As you probably know, hate crime is something that there's no such an offence as a hate crime. Yeah. Hate crime is more a means of police recording incidents that are perceived by the victim to have been motivated by hate. It's a slightly broader definition, and there are more protected characteristics than there are in the current law. I'm not quite sure exactly what is meant there by defining hate crime further within the legislation.
Yeah. I think there was a recommendation from Judge Marnin's review that there needed to be a firm definition of hate crime. And we discussed that, but it's just something that came through very clearly last week, and it just was something I was wondering if the PPS had any views on.
No, we
there need to be clear definitions of the offences and the matters that need to be proved. So there needs to be legal certainty, and we need to be able to apply them properly. But I don't see why a general descriptor of a type of crime requires a definition in legislation for the purposes of the criminal law.
And just following on that, I think you talked about how the 2004 Criminal Justice Order doesn't have a mechanism for recording on a criminal record that a sentence was aggravated by that hostility. Do you think the current provisions then in this bill would adequately address that?
Yes, that's my understanding, is that is part of it. Is that actually covered in the bill, or is it? Yes. Well, you're maybe making a fair point here that I haven't discovered or considered before now. Clause 36(4) states that the court must state on conviction that the offence is aggravated by reasons of the victim's vulnerability, record the conviction in a way that shows that the offence is so aggravated. So I suppose it's a matter of ensuring that the court, when the court records it, it might be a separate process to actually what appears on a criminal record. That might be for the purpose of the court's records or the order book or something. So it maybe the legislation on its own doesn't result in that aggravation appearing on a criminal record. So that's something maybe I would need to give a little bit more consideration to. But certainly my understanding has been that this should appear as a racially aggravated assault or whatever on a criminal record, and that there's transparency around that.
I think that's recognised as a gap at the moment, so I think it needs to be there.
Okay, just another two, if you don't mind, quick ones. I'm interested in particular on the comments you'd made to us around vulnerability and how it being quite broad might be difficult to interpret. And I think you'd said in your remarks, and absolutely correct me if I picked that up wrong, that you think the courts can currently consider vulnerability of victims. Could you maybe talk a wee bit more on that and how you think that's been adequately addressed then already?
Yeah, so the courts do, day in, day out, deal with vulnerability as a part of the sentencing process. And I don't think there's any perceived gap there. I suppose what I'm concerned about is, and vulnerability can arise in a range of circumstances. And I was looking at a case the other day, and the vulnerability arose maybe from the circumstances in which the offender had sort of isolated the victim from her friends and so on, and that was treated as vulnerability. And I did start to think, well, would that actually satisfy vulnerability? And I did start to think, well, would that actually satisfy the test of vulnerability that's laid down in this legislation? So at the minute, we don't have to allege it up front. The case will take its course, and if the defendant is convicted, there may, in the Crown Court, be submissions around what the relevant aggravating factors are, and we would submit vulnerability, and the court would weigh that with all the aggravating factors, but it wouldn't single out vulnerability usually in terms of how it is affecting the sentence. So it might take a starting point. It might say, well, there are these aggravating factors as a result of which, one of which is vulnerability, I'm going to increase it from 6 years to 8 years. And it's not, at the minute, it's just not really, it's not an area of the law or of the practice that is giving rise to any operational difficulties. It just seems to us that it works well and doesn't really attract any particular challenge from the defence. And there's considerable flexibility as to what the court will find vulnerable and what material it will rely upon in order to make that finding. By taking vulnerability and making it an aggravator, you're putting it up there at the outset of the case. That's something that the prosecution has to evidence and prove beyond reasonable doubt. You're drawing more attention to vulnerability, not just in terms of the outcome, but in terms of the defendant and the defendant's legal team thinking, well, okay, they're trying to add vulnerability here. Is there any way we can get that knocked off in some way, or is there any way that we can challenge that evidence to ensure that the prosecution don't come up to proof on it? And part of my concern is the thresholds that are involved there. The onus beyond reasonable doubt. We have to prove substantial impairment. And we have to prove a mens rea element of it, which is that the defendant knew or ought to have known about the vulnerability. And so I think we're just, with this, potentially bringing a lot of additional scrutiny and factors around proving vulnerability that we don't really have in place at the minute. And I'm just not sure that that is going to result in better outcomes for victims.
Grand, that's grand, thank you.
All right, Connie. Brian?
Thank you, Chair. Thank you for your answers so far. Michael, I might have some repetition here, but I'm just trying to understand. In terms of Clause 2, the duty to follow sentencing guidelines, I mean, to me it sounds like a good thing that there should be public understanding of where sentences come from. It's not just pulled out of a hat, like a surprise. That it's understood how it follows. There's consistency, in sentencing. Yep. So, to me, that sounds positive.
Yes.
And I think you've said that would normally happen to some extent.
Exactly.
I think the only negative you threw up was that it would take longer.
So I suppose there are two aspects to it that cause me some concern. The first is the fact that it applies to the Magistrates' Court and the Crown Court. Okay, and the idea that it would take longer really is a point that I make in relation to the Magistrates' Court.
Right, because there's a higher volume of cases.
There's a higher volume of cases, but no, it's because current sentencing practice in the Magistrates' Court is sort of short, sharp, and to the point.
More standardised.
And more standardised, yes. It's less legalistic and probably less complicated and less requiring in explanation. Maybe a slightly inelegant way of putting it. So the fact that it applies to the Magistrates' Court is one concern. And then the only concern that I have in relation to the Crown Court is the fact that the court is now, it happens to some extent, so it is quite a sort of subtle point, but the court is required to identify guideline judgments, and it's not so much a part of the problem arises from the fact that I think at the minute there's sometimes a lack of clarity as to what is a sentencing guideline judgment. I think the Court of Appeal more recently has been quite clear, sometimes saying this is a sentencing guideline judgment. Sometimes there's even a heading on the case, guideline in relation to sentencing for X and Y. But historically, there are cases that the court wouldn't have said that, but they've sort of become known to be guideline judgments. Also, the Lady Chief Justice's sentencing group has done some work maybe in identifying those cases that should be guideline judgments. But speaking to some of the prosecution counsel who would do work for us, they would advise me that there is still an element of ambiguity at times around which previous cases should properly be considered guideline judgments. So I suppose the fact that there's now a statutory duty on the court is just maybe bringing a bit of sharper focus on the challenge that might present and the risks if the court gets it wrong, or the potential for the prosecution and the defence to disagree about whether a case is a guideline judgment. And all of that could become a bit of a distraction, where everyone is focused on complying with this statutory duty in circumstances that are quite difficult and in which there may be grey areas. As I say, with the sentencing guideline from the council, there's no grey areas. It's quite clear. That's what you follow and that's what you apply. But with the way our sentencing law has evolved over the years, there are some grey areas, and it could result in a bit of a distraction, which is actually what we want. I think it's not what we want. We want almost less discussion of previous cases, shorter, more accessible sentencing judgments. Not necessarily a judge going through all the cases that the different parties have argued are sentencing guidelines, and the judge potentially trying to explain why he has or hasn't agreed with the submission from either party, and then potentially the defence going on appeal and saying, well, the judge was wrong to say that this wasn't a sentencing guideline, or that this particular Court of Appeal judgment didn't contain guidance which was relevant to the court's sentencing function in this case. So absolutely, I can totally understand why you would say that transparency, following guidance, consistency are all laudable objectives, which they are. It's more the practical operation of this provision in this jurisdiction that gives me some concern.
Right. And are you thinking it might provide grounds for more appeals?
I would hope not. I can see arguments being made on appeal of the nature that I described. When dealing with an appeal against sentence, the role of the court ultimately is to decide whether the sentence was manifestly excessive. So it's really the end result that is the important bit, rather than necessarily how the court got there. It's not really a public law type exercise, but I only flag, I suppose, the potential for those types of arguments to be made.
Yeah, no, thanks. Okay, well, moving on to the aggravation. I'll make a few comments on this. First of all, a note: the aggravation by hostility is easier to understand. Racial, religious, sexual orientation. Now we then have disability, which is also in the vulnerability section. Where it talks
age or
specifically disability, physical or mental disability. So in my own head I'm wondering, well, is disability, is that a hostility or is it a vulnerability? In this case it's both.
Yes. In practice, I understand exactly the point you're making, and in practice it's probably more often vulnerability than hostility.
I'd have thought so.
Disability has always been a protected characteristic under hate crime laws, but one of the observations that various commentators have made is that offending against disabled people is rarely motivated by hostility towards disabled people as a class of people. So it's a slightly uneasy fit within a hate crime model. And I think that's been recognised by Judge Marinan and by the Law Commission in England and Wales, who did a report in December 2021, which has led to some discussions around whether the sort of hostility model is correct for disability.
I've yet to reach a final position on that, but I'd have thought it more fits in as a vulnerability. And in 36, so the idea of the vulnerability is where someone is abusing their power, really, over a perceived weakness or an ability almost to bully or whatever. And that has that desire to exercise power
It's
has
not
been a factor.
The vulnerability aggravator is not about the targeting of the individual. A lot of people do have offences committed against them because they are vulnerable to some extent, but it's a bit different than it's the presence of the vulnerability gives rise to the aggravation rather than a motivation by the offender to commit an offence against somebody who is vulnerable. The definition is in the bill at 36(7), which is either a person under the age of 18. And I have to say, when I saw that, it did occur to me, well, in the youth court where we have young people committing offences against other young people, should we be applying a vulnerability aggravator in those cases now because somebody who's under 18 is vulnerable? I don't know the answer to that yet. I haven't really thought that, but it seemed maybe a little bit odd that might be doing that. Or the alternative definition is a person whose ability to protect himself or herself from violence, abuse, neglect, or exploitation is significantly impaired through physical or mental disability or illness, old age, or for any other reason. So that's what it's targeted at.
And I get what you're saying there about the definition of significantly impaired and or for other reason. I mean, we have age included here, and I suppose it's making the point, it's not just the age, it's the fact of frailty, maybe, and there could be an argument of, for all of us, when do we become frail?
You can see how it can be very difficult to define or to make judgments as to when that threshold is or isn't met. Yeah. And I think this is placing a lot of onus potentially on prosecutors to make very difficult sort of judgments around that. Whereas I think maybe a little bit of constructive ambiguity is the right word, but I think the process works quite well as it is at the minute without having to formalise it in the way that this provision envisages.
So, are you suggesting 36 should be left out, or somehow?
I would rather vulnerability is dealt with as it currently is dealt with than be dealing with it under this provision.
But how is it currently dealt with that people can see? I mean, so my question is, does the aggravation by vulnerability under this, would it need to be declared at the start?
Yes.
And actually included by yourselves?
Yes.
It's not something that can be taken into account or arise during the case or something? It has to be declared at the start?
Yes.
Is that the difficulty for yourselves?
One of the difficulties is potentially we have to do that, and then we might have to make disclosure around it. And you could see if we were saying like a victim in this case is vulnerable and it may be circumstances relating to their background or any trauma that they have, you could then potentially see the defence saying, oh, we don't accept that. We'd like to see anything that might assist us in challenging that. And that's not a situation that would be particularly good in my view.
Right. It just puts an onus on yourselves then to decide almost whether or not to include it.
It does, and
as an aggravation.
It does, and there's no problem in a sense in putting certain decision making on the shoulders of prosecutors, but I don't. I struggle to see the difficulty with how vulnerability is dealt with at the minute. I mean, it is well recognised as an aggravating factor. There's flexibility in terms of the different types. I don't think the courts have ever had to get into defining vulnerability in a very technical way in order to deal with it as an aggravating factor in sentencing, and it is routinely taken into account. And I think the courts seek to protect vulnerable people that way. This is just bringing obviously it's a different way of approaching it, but it has some problems.
I suppose a lot of this bill is trying to take like custom and practice and actually put it into law. Even like the start saying what the purpose of sentencing is, things which we might think we know, but it's actually trying to, let's actually put it down.
And there's absolutely value in that. I would say this provision isn't doing that. It's not really just declaratory or stating what the law is, or a bit of legislation could potentially say, like when a court is sentencing, the following should always be considered as aggravating factors, and it could say vulnerability is one of them. That's fine. That, I suppose, potentially would maybe increase a bit of public understanding around what might aggravate a sentence, but it doesn't actually interfere then with the prosecutorial process or what it is that we have to prove or give rise to disclosure obligations. So there are ways that you could potentially raise some public understanding around how vulnerability is dealt with, without necessarily bringing in quite technical provision like this that requires an aggravator.
And briefly, when you say about how it's currently dealt with, how is it brought into the
It's really
case?
focused upon at the sentencing stage.
Right.
So the prosecution and the evidence, the trial and so on will focus on the elements of the offence which don't have vulnerability as an element of it. And then really at
It's not an offence, it's an aggravator.
well, exactly,
to an offence.
exactly. But it will become something that will be upfront, and the jury will ultimately have to, under this model, the jury will be the ones who'll have to make a determination around vulnerability, and the judge will have to give the jury directions around that. So the jury will not only have to maybe find whether the defendant is guilty on all of the counts, they'll have the additional responsibility of making a finding around vulnerability. The judge will have to give them additional instructions around all of that. So it is definitely adding to and potentially complicating the jury's task. You may have a situation where you have multiple aggravators. When you think a lot of the domestic violence cases that we have offences that are aggravated by domestic violence, and the domestic violence aggravator will go on. In the vast majority of those cases, I'd imagine the victim's going to be vulnerable as well. So you're going to start to layer multiple aggravators onto a prosecution and onto the role of the fact finder.
Okay. And I don't know if can I ask one more question. Is it going to
Make it brief.
It's a big question, but sex is not a hostility. Have you a view on that? And obviously, with the appalling litany of crimes in Northern Ireland which have occurred against women, do you feel sex should be included as an aggravator?
Yeah, well, I think when it comes to whether other characteristics should be added, we've tended to really take quite a neutral approach to that. I'm aware of the debate around it. I'm aware that Judge Marinan recommended, I think, gender being added as a characteristic, albeit he I think also wanted to change the hostility focus of the hate crime test, or the hate crime model. He wanted it to become a sort of a broader, the by reason of point. It wasn't just linked to hostility. The Law Commission, as I mentioned earlier, in England and Wales, did a very, very detailed report which was published in December 2021, and they looked at it and they also concluded that adding, well, not also, but because maybe Judge Marinan took a different view, but within the framework of their existing hate crime model, they didn't think that it would be helpful to add sex as a protected characteristic. I think they felt it would be difficult to prove hostility in relation to gender. I think they were worried that you would have some cases to which it potentially could be proven that it would be attached and others that it wouldn't, and you'd end up creating a bit of a hierarchy of victims, which they thought was undesirable. And I think they felt that gender wasn't analogous to existing hate crime groups, where a lot of the characteristics that we have are generally involving hostility directed towards a group perceived as another. And whilst they recognised that violence against women and girls was a very significant problem that the criminal justice system needed to address, they thought that it frequently occurs within intimate, familial or sexual relationships, and that they considered that the social dynamics are different and are not always captured by the hate crime model. So they thought violence against women is a distinct phenomenon that should not simply be folded into the hate crime framework. And I think they felt, and maybe whether the CPS fed into their views on this, ultimately was the addition of that characteristic going to result in more prosecutions or more convictions? Or was it going to maybe add another challenge to the prosecution of these cases, which are already very difficult? Sexual crimes and domestic violence in particular are challenging cases at the minute. So adding that characteristic, I suppose, has the potential. I mean, there are obviously arguments that can be made in favour of it and so on, so we don't take a particular view, but operationally it wouldn't be straightforward.
Okay, thank you.
Okay, Brian. Ciara, online.
Thank you. I'm just going to go back to clause 26, aggravation by vulnerability, and obviously we note, I think your opposition to its inclusion in it and the reasons why.
Yeah.
And you have said that it's kind of routinely taken into account. I think there's a public perception there that needs to be clarified how it is routinely taken into consideration. But I'd like to ask, is there any other jurisdictions that currently have vulnerability as a aggravator?
Not that I'm aware of.
Not
No,
that you're aware of.
no, and I think this The original policy proposal was really about adding age, or creating either as a protected characteristic or maybe a new statutory aggravator relating to age, probably the former. And so it kind of evolved into something that is quite unique, I think, as a proposal. So I haven't done a very comprehensive comparative exercise across multiple jurisdictions, but I'm certainly not aware, GB or Ireland, that they've gone down this route, or that anybody has actually proposed going down this route. I think it's at the minute a conversation that's unique to this jurisdiction.
Are you aware of any work or research that has been done on how it's used within court and routinely used within court? Because I'll be honest, there is a perception, and I've had a range of, particularly parents and stuff, that those, I suppose, that are most susceptible to crime are those that are most vulnerable, whether it's our young people, those with addiction issues, those disabled, those isolated in their homes. And it's a feeling that sentences are lenient. Yeah. And given the level of vulnerability, they're not seeing a higher sentence because of that. And that's just a general perception from individuals that I've dealt with. So having it up front is something that a lot of people, particularly parents, individuals who have had crimes against them and the sentencing, and seeing, to be honest, seeing individuals continuously going in and out of court 100, sometimes 200 times, they're feeling the sentence is too lenient, despite the fact that these people preyed on our most vulnerable people, our children in our care homes, our young people that may have mental health issues, capacity issues, etc., etc. So that's a perception out there, and it's just trying to get clarity on how it's used currently, how strong it's used within sentencing. So I'm kind of on the fence at the minute, because I can get it from local people how they're feeling. So I don't know if you want to comment on that.
Well, I mean, obviously you're referring there to a range of aspects of vulnerability, but probably a more general societal concern about levels of sentencing, which may be slightly broader in scope than specifically the issue of vulnerability. As I say, it's difficult because, as I say, you could have something that says in law that vulnerability should be taken into account as an aggravating feature. I suppose, how would the public get some reassurance around that? I don't know whether the accessibility of sentencing remarks is something that can help that over time. And I can't remember where we are with that. I don't know. There was certainly consideration being given to a pilot around the accessibility of sentencing remarks. I think making them more accessible in terms that the public can get them easier, and also in terms of how they are set out, and that maybe goes back to my argument earlier about Sentencing Guidelines Council, as a result of which I think they can be made more accessible, a bit more easy to understand for the public. I'd maybe suggest that is potentially a way forward. It's obviously it's a long process to change public perceptions around sentencing, and vulnerability will be dealt with differently in each individual case. But whether through, certainly in some very high-profile cases, if people could see the sentencing remarks and could see how vulnerability was addressed by the courts, that might start just to give people some reassurance.
Okay, no, thank you.
Thanks. Ciara Morris.
Thank you very much, Chair. And Chair, apologies for being late. The previous committee ran on a little bit. And apologies for not hearing your full presentation, so I'll only concentrate on a small part. And Ciara has already touched on it, and that's the vulnerable aggravation. You don't seem to be in favour of it. So are you suggesting that we as a committee narrow the definition of vulnerable aggression?
Unfortunately, I'm being a bit more radical than that, I think.
You want to wipe it out altogether?
Yeah, I would. The breadth of the definition is one of the issues, but I suppose still a narrower definition might still give rise to difficult judgments, in terms of whether or not it should be included within the charge. It might also exclude people who are vulnerable in a sense. So the breadth of it has quite some difficulties in application, but I'm not worried about we want to capture all types of vulnerability. I'm not worried about the definition being too broad from that point of view. It's just the breadth of it, I think, also maybe diminishes some of the messaging. That, you know, because it can arise from the circumstances of the individual, can arise from the circumstances of the offence. It just arises in so many different ways that I'm not sure how clear the sort of labelling or the messaging to the public around it is. But I think, well, you picked me up right, maybe from, I don't know if you read something in advance or from my answers to previous members. I am concerned that this is going to make it a lot more difficult to deal with vulnerability effectively than the current system.
Do you think it'll complicate investigations? Or complicate the sentencing?
So, good question. It could potentially complicate investigations because, as I said at the start, we're now attaching vulnerability to something that we're having to prove before the jury or prove as part of the trial process. And I think it's much more likely to become contested in those circumstances between the parties. And the defence are going to want to probe underneath the bonnet and seek information that might assist them to challenge that. Second part of your question there, sorry, it just slipped my mind.
Do you think it would complicate the sentencing?
Well, the sentencing, so potentially, I mean, it's not that difficult for, particularly in the Crown Court, because I guess this will probably apply in both the Magistrates Court and the Crown Court, I would imagine. Actually, I haven't sort of addressed my mind to that point, but it's certainly in the Crown Court we have a more methodical approach to sentencing, and this could be accommodated within it. That said, aggravators do give rise to some areas of complication. The domestic violence aggravator, I mean, the Court of Appeal adopted a particular approach to that within the sentencing framework, but then a number of months later decided that it had got that wrong and changed how it implemented the domestic violence aggravator in the context of sentencing. So these new areas of law, new mechanisms can give rise to some complexity and mistakes can be made. And I think once you add more aggravators and potentially multiple aggravators in an individual case, it does complicate the sentencing process.
Yeah, and do you think there's a possibility that there could be unnecessary disclosure of some personal information that a victim may not wish to disclose?
Well, I think it makes it more likely because, as I say, it's something that is advanced at the start of the case. And again, I did sound some of my thoughts on this, use as a sounding board, some of our very experienced prosecution counsel. They shared that concern as well.
It's helped me make my mind up. Thank you.
Thanks, Maurice. That's you. And sorry, just before I let you away, I wanted to go back. Brian had asked you some questions there around adding sex.
Yeah.
I know that in terms of the Scottish working group, they had actually advised adding misogyny as a standalone aggravator. I wondered if you had any thoughts on that.
I suppose it's not something that I've probably studied in enough depth to want to go authoritatively on the record on it. But I do know that, again, for those who are particularly interested in this subject, that the Law Commission's report, I think, also looks at misogyny as well as an alternative to gender as a potential protected characteristic. And I think the Law Commission felt that that type of model would suffer from many of the same difficulties as the gender model. They considered that defining misogyny is difficult in criminal law. The law requires relatively precise definitions and evidence, and the Commission was concerned that misogyny often, just to quote my notes if I can, manifests as ingrained attitudes, power dynamics, entitlement, or structural discrimination rather than explicit expressions of hatred. These features are real but difficult to translate into a criminal law test. They said, second, misogyny is not always hatred. It's kind of related to the previous point. The way it manifests itself is quite different, maybe to a sort of a hate crime type situation. And then they also thought misogyny could make prosecutions harder. They said if prosecutors had to establish a misogynistic motivation, in addition to proving the underlying offence, this could introduce extra issues in already difficult cases, particularly rape and domestic abuse prosecutions. So I suppose I am highlighting some of the operational concerns with my prosecutor's hat on. I recognise that there are wider issues to consider than the purely prosecutorial ones, but I do see it not being straightforward to apply.
Okay, thank you very much. Thank you.
Okay, thank you.
Thank you.
members, there was an addendum from the PPS, which you'll find at pages 31 to 36 of the meeting pack. Can I have your agreement to forward that paper to the department in order to receive responses to the points that they raised? Yeah, content? Is there anything else that anybody wants to raise at this point? No? So we'll move on to agenda item 5, and we'll give the presenters a wee minute to get themselves organised. Members, from page 37 to 50 of your meeting pack, you'll find the relevant papers from the PSNI. We've got a written submission from the Police Federation, which can be found at pages 3 to 7 of your table pack. So I want to welcome the presenters here today. We've got Gary MacDonald, the Chief Superintendent, Louise Cummings, Chief Inspector, and Paddy Mullen, Chief Inspector. So thank you all for coming to our meeting this afternoon, and welcome you, and open the floor to yourselves for any will.
Thank you, Chair and members of the committee. Thank you for the opportunity to provide the Police Service of Northern Ireland's views on the criminal justice, sentencing, etc. bill. As you said, my name is Gary MacDonald. I'm Chief Superintendent from PSNI's Justice Department. It's good to see you all again. And I'm here today with my colleagues, Chief Inspector Louise Cummings and Paddy Mullen. At the outset, I think it's important that we do state that PSNI welcome the direction of travel of this bill. It is a substantial reform package which in many respects will strengthen transparency, consistency and public confidence in sentencing. We see real value in the clearer statutory emphasis on public protection, in improved mechanisms to correct outcomes that appear unduly lenient, and in provisions that directly reflect the harm caused to victims' families and communities. We support in particular the bill's decision to place the purposes and principles of sentencing on a statutory footing, punishment, public protection, deterrence, rehabilitation and reparation, underpinned by proportionality, fairness and transparency. The duty to follow sentencing guidance and to explain in open court when departing from it should help improve consistency and understanding of decisions. Operationally, that matters to us. Consistency strengthens confidence, helps manage expectations with victims and families, and creates a clearer framework around how the justice process reaches the point of sentence. We do, however, want to be candid about what that means for policing in practice. A more explicit statutory framework inevitably increases the premium on evidencing aggravating and public protection factors to the required standard. Across investigating teams, whether in serious crime, public protection, neighbourhood policing or other specialist functions, there will be a heightened requirement to ensure that case files demonstrate the seriousness and impact of offending in a structured way that aligns with the new statutory purposes and aggravations. That means more focused evidence gathering, more supervisory oversight of file quality, and earlier engagement with prosecution colleagues where aggravators or tariff impacts are relevant. Within that context, PSNI welcomes reforms that strengthen outcomes and confidence in serious cases. The provisions on life sentences, particularly the statutory starting points and the requirement to explain life sentences in plain language, should improve transparency for victims' families and reinforce public confidence. Similarly, extending the unduly lenient sentence regime to all Crown Court sentences closes an important gap and provides a meaningful safeguard where outcomes appear manifestly inadequate. While decisions properly remain with the Director of Public Prosecutions and the courts, it strengthens confidence that the system can indeed correct itself. PSNI also recognises the significance of the provisions relating to failure to disclose information about a victim's remains following tragic circumstances involving murder or manslaughter. These measures create clearer consequences for deliberate non-disclosure, offer structured incentives for meaningful disclosure, and require parole commissioners to take non-disclosure into account in making parole decisions. From a policing perspective, that can provide important leverage and, crucially, supports families who endure the unique trauma of not being able to lay their loved one to rest. We support the statutory aggravation frameworks, including aggravation by hostility and by vulnerability. These changes will be welcomed by victims and those who advocate for them, and they should bring more consistent sentencing and clearer recognition of harm, including the wider impact of hate-motivated offending on communities. Operationally, the challenge is evidential. Proving hostility motivation, defining the term hostility itself, or establishing that an offender knew or ought reasonably to have known of vulnerability often requires additional background information, appropriate lines of inquiry, third-party material, digital evidence, and a clear articulation in the prosecution file. Without clear operational guidance and consistent training, there is a risk of uneven application, contested cases and avoidable delay. However, done well, these provisions can strengthen outcomes and enhance the service provided to victims. In relation to road traffic matters, The latest annual collision report shows that road harm has increased in 2025-26 compared to the previous year. Injury collisions, overall casualties, fatalities and serious injuries have all increased. The calendar year to the 14th of June records 31 fatalities compared to 21 the same period last year. In this context, we welcome the strengthened approach to road traffic offending, including the creation of a distinct offence of causing death or grievous bodily injury by driving whilst disqualified, enhanced sentencing provisions for dangerous driving causing death, GBI, and causing death by careless driving whilst being unfit through drink or drugs, moving these from 14 to 20 years. We also welcome the enhanced provisions for repeat offenders, not just in sentencing but in relevant disqualification periods. This reinforces the seriousness of deliberate disregard for court-imposed disqualifications and should be welcomed by victims and their families. We would flag what appears to be an inconsistency with sentencing in relation to causing death or GBI whilst driving whilst disqualified. The draft legislation indicates 4 years imprisonment on indictment for the new offence. This is in stark contrast to what is being suggested in relation to the other offences causing death or serious injury, particularly given this offence is a clear disregard for the court and by its nature indicates a repeat road traffic offence, one which has now resulted in the death or serious injury of another. Again, against that broadly positive picture, we do have two key issues for the committee that we would like to raise. The first is the proposed expansion of suspended sentence orders with community requirements. We recognise and support the policy intent. The evidence suggests that well-resourced community supervision in appropriate cases with effective support mechanisms and the required infrastructure can reduce offending and improve longer-term safety. The concern is that, as drafted with the current information available, the operational impact on policing is not yet fully articulated. There is no published demand modelling to quantify how many additional offenders will be under supervision, how many breaches are likely to arise, what volume of enforcement activity could follow, and what that actually translates to in respect of calls for service, arrests, and risk management activity for the police. In plain terms, if community supervision capacity is stretched, the risk is that unmet demand does not disappear, it just potentially reappears as police demand, and with current resourcing and demand challenges, policing capacity is limited and it will be challenging to absorb this. If breaches are not detected early or supervision is not robust, the consequences may land on PSNI and the communities we serve. We therefore ask the committee to seek clear assurance that the Probation Board for Northern Ireland will be sufficiently resourced and operationally prepared before these provisions commence, so that risk and demand are not inadvertently displaced onto policing. Our second and most significant concern relates to assaults on police officers within the public worker provisions. PSNI supports strengthening protections for all public-facing workers through the new offence of assaulting a public worker and the aggravation framework for serious offences committed against public workers, especially the increase in sentencing on summary conviction from 6 months to 12 months when compared to the standard assault on police offence, which is only 6 months on summary conviction. This is a significant step in recognising the risks faced by all of those delivering public services, and we support strengthened protections for all frontline workers. However, the bill's consequential amendments remove that existing police-specific offence of assaulting a constable contrary to Section 66 of the Police Northern Ireland Act 1998. The Police Federation has been clear that while they support enhanced protections for all frontline workers, the new offence must complement, not replace, the existing assault on police offence, albeit we would like to see a similar increase to the sentence available on summary conviction for assault on police, similar to that what is proposed for frontline workers. It is important to note that any increase will only have the required impact if custodial sentences are utilised. The Police Federation view reflects the operational reality that police officers are distinct. They are required to intervene in volatile situations, face violence on a regular basis, move towards danger to protect the public, act on behalf of the state to protect all of us, and exercise legal powers such as arrest, search and restraint in order to meet statutory obligations such as preventing and detecting crime, bringing offenders to justice and maintaining public safety. This unique role means assaults on officers in the execution of their duty are qualitatively different from assaults in other public-facing contexts. The Federation highlight the scale of this issue, noting that assaults on police officers occur at an average rate of around 7 per day. We are concerned that removing a named police-specific offence risks blurring the seriousness, weakening deterrence, obscuring the true scale of violence through less distinct recording and impacting workforce confidence and morale. We would highlight that if the proposed bill progresses without change, safeguards such as the following are essential: explicit statutory recognition of police officers as a distinct protected category, clear sentencing guidelines requiring meaningful uplift for assaults on police, mandatory recording of cases involving police officer or staff victims, and ongoing monitoring mechanisms. Finally, we would wish to highlight implementation costs and dependencies. Like any bill, the cumulative effect of reforms will require practical adjustments, updates to crime recording and case management systems to capture new offences and aggravators, changes to charging codes and templates, training for frontline officers and investigative staff, supervisory guidance on file standards, and clear internal and external communication so that staff and partners understand what has changed and how it is to be applied. All of this comes at a cost, both financial and in organisational capacity, and this will require adequate lead-in time to operationalise. In closing, Chair members, notwithstanding my comments, PSNI broadly support the bill and the improvements it makes to public protection, transparency and victim-centred justice. Our message is simply that the operational foundations such as resourcing, demand, understanding, IT readiness, training and communication must be in place so that the bill delivers its intended benefits without avoidable pressure being transferred onto policing or being introduced into cases that matter deeply to victims and communities. Thank you for that. We will continue to engage constructively with the committee as your scrutiny proceeds, and we're happy to take your questions now.
Thanks very much. I think you've answered my first question with the latter part of your statement there around, and there's been some concern around this new offence of public worker and what exactly that looks like. And I would have concerns around whether or not it creates a hierarchy of victims. But the comments that you made there relating to the offences on PSNI officers, so I'm assuming from that we won't then have data that is aggregated by specific type of public worker in order to be able to identify where the particular pressures are. Is that what I can?
Yeah, I mean, it could be, we could look at it. I don't have the data to hand today in terms of looking at a level of assault, what the motivation is, and then the employment of the victim. It's something that we could potentially look at. It's something that we do capture where it is available. So it's something I couldn't answer today, but could potentially take away and look at. But I get your point as well. It's about maybe trying to ascertain, look, where is the demand? Does it fall on health staff? Does it fall on security staff, or people who look after shops, for example? So it's probably a little bit of work. But I think it is important to clarify that we do support protection for other frontline workers. I think it's just given the unique nature of policing, and it's reflected, I think, in the submission from the Federation as well, that we think there is enough grounds to justify why there should be difference there in terms of policing.
So I take from that you think there'll have to be some amendments made or some changes to how PSNI record data or the systems that you use? Yeah.
It would. So if it went unchanged, it would be hard to differentiate then in terms of, well, what was the specific occupation of the victim? So we would have to figure out a way to be able to do that. I mean, it's not insurmountable. I'm sure we could do that internally, but I think it's just in terms of having that data at a high level, in terms of what is the rate for assault on police against that legislation as it stands, is quite easy to extrapolate now. And as I say, the Police Federation use it to inform their Let Them Protect campaign. It's a very sort of clear messaging in terms of articulating the scale and the demand of assaults on police officers and how we are actually an outlier when you compare figures across the UK. So I think all of that will be more challenging to do if essentially it was just one kind of cohort of assault on a public worker.
And in terms of the repeat offender provisions and the uplifts to sentences, have you considered the pressure that is going to lead to in terms of our prisoner population, or is that something the BSNI have given?
Well, it's something that we would obviously be alive to with our partners across the Criminal Justice Board and within the prison service. But I suppose it's not something that we would necessarily have obviously direct control over. We work with our colleagues in the DOJ. I know there's different arrangements in place around trying to reduce the prison population, and we work with colleagues around managing that. But it's not a thing that we would necessarily have a view on.
Okay. I'm going to move to the rest of the committee. So, Connie.
Yeah, thank you for coming in today. It's really, really useful. And I think the only real question I have is around your concerns. I think you'd raised especially the operational impact that some of this will have on policing, and the community supervision capacity and the assaults on police. I just really wanted to know, how have you engaged with the department around your concerns when they've been drafting this bill, and has there been ongoing communication? Have you put your concerns to them?
Yeah, so we have, and they're aware of the fact that we'd be quite keen to try and articulate just exactly what that demand looks like. I think the bill talks, for example, if there is a breach if there's a further offence during a suspended sentence order, or there is a breach of a community requirement, it's for the probation board to go to court to satisfy a magistrate, which would then ultimately issue a bench warrant or a summons, which would potentially obviously translate to us the action. But it's just not clear what that sort of demand looks like. So we have engaged with the department around that, and there's a working group which Louise sits with the department, and obviously it's still quite early stages at this point in time in terms of just working through what operationalisation would look like, but that engagement does continue and we have flagged that.
Mm-hmm. Have you got like any reassurances for some other issues that you've maybe raised with them previously, and how do you see that working group operating? Do you think you can address them, or as well as issues that you want us to raise as a committee?
Yeah, I'm confident that we can work through it with the department through the working group. And I don't know, Louise, if you want to talk about the working group and the work so far. There's no, I suppose we haven't necessarily got an agreement at this point in time that we will necessarily get that data that we require, but we can work through that, I suppose, just through the working group. But I'm confident, yeah, we can work constructively with the department around just trying to ascertain that, because it helps us obviously operationalise this bill as effectively as we can. Is there anything you want to say, Louise, just around the actual working group and the work so far?
Just probably just around discussions around the assault on police and the changes around that. We've had a good discussion as to where this whole public worker offence has come from, and the sort of the journey along the way to be able to understand it, which is why we support that. But it's just the elements around the assault on police aspect that we have concerns with. The boss here has already outlined.
That's grand, thank you.
Okay, Connie, thank you. Brian.
Okay. Thank you, Gary and colleagues, for your paper and your attendance. I think you said, in terms of the aggravation, you said the police would have, the implications of this, are you saying the police would have to put more effort into proving the aggravation? I mean, in our earlier session, which you heard, if you can explain how aggravation is currently dealt with, that it can be, the judge can almost identify it, or, well, I suppose the prosecutor can identify it, but are you concerned this puts more onus on the proving of it?
I think what we're saying is that, yeah, I mean, if it's a clear statutory aggravator from the outset, then it will be incumbent on the PSNI to be able to take that into account in their investigative strategy, to be able to prove that, to ensure there's sufficient evidence on the file when the file is submitted to the Prosecution Service. They can make the appropriate decisions, and then once it obviously gets to the point of sentence, then the judge can declare the fact that it has been aggravated by hostility, for example, and then pass the appropriate sentence. But I think it is important to note that we do this now to a certain degree a present, where we identify a particular criminal offence is motivated by hate. It is identified as such, it is flagged as such, and there is an appropriate investigative strategy which takes that into account. And I think the benefit of this bill, from what we can see, is it just makes it much more explicit from the outset. It makes it much more clearer, rather than kind of an articulation later on. And I think we have seen, and I'll bring Paddy in a second, who has led a lot of the PSNI work in this space. But I think it has been inconsistent when it comes to sentencing, in terms of just making sure that that aggravator has been clearly articulated and has been clearly sort of passed through the sentence. So we think this does make it a bit clearer. But yeah, there's no doubt there will be a challenge to make sure that we get our investigations right, but we should be doing that anyway, in terms of just ensuring that we get the sufficient evidence. But Paddy, do you want to?
I don't really have much more to add. I think what you sort of covered there is, we're already doing this. Where we record a hate crime, we will seek to find the evidence of the motivation, because we're very aware that at the end of the process, in terms of the enhanced sentencing process that we have now, that the judge will look to see whether there's that motivation, where there's the evidence of the motivation, and seek to enhance the sentence at that very final stage of the journey in the criminal justice process. So we're already doing that. This just provides a very transparent process around how we're doing it, and where that hate motivation maybe isn't evidenced. I suppose it provides the victim with an early indicator as to where that maybe drops off in terms of the crime that's being investigated and pursued through the criminal justice system.
Okay, you're content with what's in the bill in this regard, and what about sectarianism not being specified? I mean, religious hostility is included. So in Northern Ireland, I mean, I presume sectarianism, is it a factor in sentencing currently, or not?
No, it's not. So what's in the bill at present is essentially what the current legislation allows a judge to enhance a sentence around. So nothing has changed in terms of the protected characteristics in the law. Now, obviously, I mean, it's well known we record sectarianism as an additional protected characteristic, but it can't be prosecuted in terms of a protected characteristic. It would have to be kind of almost shoehorned into religion or to one of the other protected characteristics that's outlined in the statute.
Okay. Right, I'm just checking my understanding in terms of suspended sentence orders and community requirements, like a community sentence. Are they? Am I right in thinking they're currently two different sentences, and this will provide the means for a suspended sentence to also include a community order, or it would be a supervised suspended sentence?
Yeah, that is the case. So essentially, I'm sure there's other people who can articulate this better than I can, maybe from the PPS or the probation board, but essentially a suspended sentence right now is exactly that. You know,
people say, "Oh, you're getting off."
Yeah, well, I mean,
and I know that's not the case.
Yeah,
but that's
yeah,
the
it's
feeling.
Not the case. But ultimately, you know, if you know, there's no further offending, that's likely not to take effect. As my understanding of this bill is essentially, yes, we'll bring in additional requirements as part of that suspended sentence, which will include community requirements, which may be around kind of electronic tagging, or maybe you know, undergoing treatment, for example, for rehabilitation, drug treatment, for example, which can be built into that. And then, of course, then that allows not just for the fact that if there's further offending during the suspended sentence, but also if there is a breach of those requirements, then you could be essentially brought back to court, and then that will take place. I think the bill refers to it as an activation event. And I think we would welcome that, because it speaks more of rehabilitation and reparation, and rather than having no particular programme or no particular support during that period of time, the community requirements as part of the suspended sentence order will achieve that and hopefully reduce reoffending.
Okay. And you've already mentioned that some of the workload would fall back on the police. I mean, some of that will go to probation, does it, for community orders?
Yeah, I think so. I think the bill talks about the probation board, or people appointed by the board, the probation board. So in the vast majority of cases, this will be for the probation board to manage those community sentences and the relevant programmes. I suppose just what is unclear at the minute is if that is a significant increase of people who require supervision within the community in terms of the baseline now. For those who are maybe potentially on a probation order, for example, it's just what sort of impact does that have on probation? Can it be sufficiently managed? And if it can't, I suppose we're just flagging that is there potentially a risk for additional demand coming towards policing, either by way of reoffending or, as I said, additional maybe bench warrants or people needing arrested for breaches, if it's not effectively resourced.
Right, yeah. So in the explanatory and financial memorandum, as you may have seen, clause or paragraph 90 is, in terms of financial effects, the bill as a whole will primarily be delivered within existing resources. So whether it's fair to ask you, would you have concerns about that?
Well, I think as I said in my opening statement, it's like any piece of legislation will incur additional costs, and that's just being honest about it. You know, whether it be training, whether it be changes to IT infrastructure or systems, processes, and as I say, that specific piece around any kind of overspill of demand from the probation, we just don't know what that looks like. So I think there will be additionality. There's no doubt there will be additionality, but the quantum of that is unclear at this particular moment in time.
Okay. Last question is, in terms of assaults on police officers, as you might be aware, that has been dropped as an out-of-court disposal, which we welcome, certainly my own party. But are you saying that it would no longer exist as a standalone offence under this bill, that it will be merged into a general assault on public workers or whatever it is? Would it no longer still exist?
Yeah, my understanding is that offence will be repealed if this goes as planned.
It doesn't actually state that in the bill that I'm aware.
I think there is.
Is there?
In the amendments.
It's in the, yeah, potentially in the amendments.
It's only one element of it, so the obstruction and resistance will still stay within Section 66, but the assault will be repealed, essentially.
Okay, we'll look into that then. Okay, thank you.
Thanks, Brian. Patsy?
Okay, thanks, Chair. And really, before we get into the question and all that, I wonder could I convey my personal thanks to your officers who, during the course of the last couple of weeks, were the bulwark against violence, racism on the streets, and just really a lot of this sentencing bill here is very, very relevant to some of the cases that your officers had to deal with and had to help people be transported from their homes as their homes burnt around them. So just to convey that and place that firmly on record, that thank you. It's often maybe not done enough, but just to say that on behalf of some of the people that we have been speaking to during the course of this week, and especially. So could I want to tease out the bit, and I get entirely, and it might be helpful just by way of background, during the course of that troubled period, we'll say the last, well, it's come on nearly 3 weeks now, how many officers were injured? That might be helpful if you had that information. Maybe you don't have it immediately with you today, but how many officers were injured in that period of time?
Yeah, so the latest, I mean, we'll just confirm the absolute latest statistic, but we believe it was 42.
Yes. So, and I get entirely what you're saying about officers, what the Federation has been saying about officers injured during the course of their duty in keeping the community safe. However, I also get that too applies to many others in frontline emergency services who are in that same category. So if I can just work that through a wee bit more, and I raised earlier with the PPS representatives, and that was a distinction between, if there is one, between a public service and public sector workers. And if there is, are you suggesting then that there should be some sort of, by way of sentencing, some sort of tiered approach where people during the course of their duty as emergency workers, that should be determined to be a very serious, if not much more serious offence? Nonetheless, it depends on the nature of the offence, of course, but that should have extra weight given to it during the deliberations of the judge.
Yeah, okay, I'll just start with thanking you for your comments there as well. Over the last couple of weeks, our officers have worked under incredibly challenging conditions to calm disorder, protect lives, and just restore normality. So I thank you for that on their behalf. Yeah, so in terms of, we're not suggesting a tiered approach in that. I don't want to, almost pit one, public sector worker against another. I think our understanding is that I think, like England and Wales, perhaps initially it was a focus on assault on emergency worker, and then it's been broadened out to public worker. I think my understanding of the bill is that public worker piece is in the widest sense rather than a public sector worker. I think it's how it's framed is that public worker in the broadest sense. And I think that's why we as an organisation and the Federation as well, for example, are clear that we support those workers being protected via this legislation. However, for the points already mentioned, I think policing is slightly different, just given the fact that what you've alluded to in terms of the trouble over the last couple of weeks, and that would be our position on that. Okay,
thanks for that. Then, just to take it a stage further, then, and again, particularly but not exclusively informed by what has happened over this last while and listening to people who have been so affected and put out of their homes and indeed chased on the streets because just incidentally the colour of their skin didn't match the perceived prejudices of those that were chasing them or trying to intimidate them. Do you feel that this proposed sentencing bill would give adequate strength to yourselves as the practitioners on the ground who collate and gather the evidence? And it would be helpful to me as well, I've mentioned it before, as to how in fact that evidence is gathered by way of motivation of the individual towards a crime, and referred to earlier by the PPS. In fact, it could be the case that some of the incidents of what they post online could be hate in itself. But could you just give me some sort of an insight as to how, during the course of an investigation, if a person is spotted, that's the person who did A, B, C or D, there's racial motivation to that. Could you give me some sort of an insight as to how that motivation is also determined by what they've been posting on online sites, on Facebook, on whatever it might be, just too, because that clearly would establish at least motivation of that individual towards either direction of the crime or commission of the crime.
Yeah, I maybe starting in Paddy as the operational lead for hate crime can maybe come in with some examples. In terms of, does it bring adequate strength? I think the benefits of this in terms of the aggravator is making it statutory and it's clear from the outset. So we know and everyone knows what they're investigating, and there is from the outset that it is incumbent on us to secure the relevant evidence to prove the hate motivation, for example, in that example that you give. And as I say, that will carry the whole way through in terms of the file preparation. It will highlight that to the public prosecutor and around decision, right through to sentencing, where the judge will have to explicitly state that it was hate motivated, and then go on to explain how that has affected the TARV in terms of sentence. So I think that is all to be welcomed, because at the minute it feels a bit informal almost at the minute. So that tightens that up and places that on a statutory footing. In terms of the gathering of evidence, obviously we'll pursue all lines of inquiry, and you're right, sometimes it's just so clearly obvious by the nature of the crime and what's in front of you that it's motivated by hate. And other times that will come out through other lines of inquiry. It could be cyber-related investigations, it could be what's on the phone, it could be what's on social media accounts, for example. And all of that evidence will need to be put forward towards a suspect. But Paddy, is there anything more specific in terms of maybe examples of how we actually do that?
I think in this kind of space there's two distinct kind of groups. You've got your online bit, and then you've got your kind of in-person bit, and they're dealt with slightly differently. The online bit, obviously it'll depend on what's posted, where it's posted, how it's posted, when it's posted. All of that is a factor into how we would consider what's motivated as sort of maybe online, whether it's incitement or whatever the offence might be that you're investigating. And then I suppose in the real world, we're looking for what does the person say, what do they say during an interview. We're obviously going to interview suspects of why did you do it, and there's every chance they'll turn around and go, well, it was because I have a real hostility towards whatever that protected characteristic is. But it's like as Chief Superintendent said, we've got we will look for the evidence in terms of supporting evidence from witnesses, what the person says at the time of the offence. If it's criminal damage, often graffiti, it'll speak for itself. Whatever the graffiti is written, that in all likelihood will prove the motivation. So it's a really difficult question to answer because it will depend on the circumstances. But it's something that we do already anyway as part of the investigation.
You do feel in general that this sentencing bill could make it much clearer and not easier, but it facilitates your officers that bit more to focus in on what the aspects of the crime that has been committed by the individual or individuals.
I think it does a number of things. Certainly from a policing point of view, it provides that focus, like you say. It'll hone in the officer to understand, actually, this is what I'm investigating, and for the purpose of this investigation, this is what I need to do. So absolutely, it focuses us in, and I suppose in some respects, it makes the accountability structures a lot easier for us then to make sure that we are adhering to what that offence requires in terms of points to prove. And if it doesn't meet that threshold, well, then we look for, well, is it just a baseline offence rather than the aggravated offence? But I think, importantly in this legislation, I hope that it provides confidence to victims, because, as I said already, it provides a really transparent process around that journey through the criminal justice system of where that hostility and that motivation is and whether we can prove it or whether we can't. And I think that provides victims and communities in the wider sense, because you've sort of alluded to the violence in the last week or 2 weeks. It wasn't just against the individuals that were targeted. Whole communities have a sense of fear around that. So I think that's what this legislation will provide us with an ability to do, is to provide that reassurance that this is how we're treating it from the outset in a very transparent way.
I think that public messaging as well, in terms of this is a conviction stands motivated by hate, and this is the additional tariff, and sharing that with the public will help, in addition to the fact that will actually be reflected in the criminal record as well, that the criminal damage is not just a simple criminal damage, it is a criminal damage motivated by hate.
I think, here, with your permission, I think it'd be very important that the message goes out, through your comms, whatever, that stuff online is equally, you could get a conviction from what you post online, because that's where I've seen some of the worst stuff really around people, irrespective of whether it's the colour of their skin, their nationality, their sexual, whatever it may be. I've seen some of the worst stuff the purveyors of just hatred online there, and that feeds into the narrative that then can lead to someone having a petrol bomb put through their window. So if whatever comms mechanisms that you have as well to put that out there, look, what you're putting online, just be very careful. Thank you.
Okay, Patsy. Morris?
Thank you very much, Chair. My question's partly been answered, and it would be Section 66, the downgrading of assault on a police officer to obstructing a police officer. I don't think we as a party could accept that. In actual fact, from our point of view, an assault of any kind on a frontline worker, including, not excluding, the PSNI, should be dealt with more harshly, because on many occasions both the PSNI or nurses or doctors or firemen or ambulance drivers become piggy in the middle, and in times of unrest they become the target for both sides. So I think that the crime of assaulting a frontline worker should be more serious than a common assault, and I think the sentencing should reflect that. And also on sentencing, I would say sometimes a crime is committed. A PSNI officer goes out of his way to do an awful lot of paperwork, prepare a case to take to court, and the PPS drop it. What that does, it deflates the officer. He has wasted his time. It tells the victim they have no confidence in the PSNI and they have been denied justice. And that's something that has to be addressed as well. But certainly, and I will be brief, I have absolutely no doubt whatsoever that it should be a stiffer sentence for assault on a frontline worker, and there is no such thing as obstructing unless you stand on somebody, in front of somebody. But if you strike somebody, that's assault in anybody's book and should be dealt with as such. Thank you, Chair.
No bother, Morris. Ciara?
Sorry for the delay there. I was waiting for questions from Morris. So just thank you. And just in relation to, obviously we had a previous presentation from the Public Prosecution Service, and you may have heard when just at the end there I had raised in relation to clause 36, aggravation by vulnerability. And obviously they have raised concerns that it's already taken into consideration at sentencing where it's an issue, and that it would, by including it now, this would add unnecessary complexity to the investigation and prosecution of cases. I just want to hear your thoughts on it. I know you are supportive of it, so just your thoughts just on Public Prosecution Service and what they're saying, and what's your general thoughts on that?
Yeah, no problem. I didn't hear fully what the PPS were saying just before we came in, but I think it was something around just articulation around the challenges of evidencing that. And I think we agree with that. You know, there will be, I suppose, just like the aggravation by hostility, there will be additional challenge to evidence where that comes from, and it'll be the same within vulnerability. But again, I think we would do this. We do this anyway, you know, in terms of our existing processes. We identify vulnerability, but I think what this does is, given the fact that there's a huge amount of demand in terms of vulnerability that we see, having a specific offence there or aggravator, we can see the merit of that. Albeit we do understand that it will bring some evidential challenges as well. I do agree that the definition is quite broad, you know, particularly that piece around or any other reason. But we have, I suppose we've overcome this before. If I think about even my own previous experience in public protection branch and the whole adult safeguarding framework, there is a definition there of what an adult safeguard investigation is, and that's essentially around, and from memory, an adult at risk of harm and in need of protection. So there might be opportunities potentially to kind of tighten up what that definition of vulnerability looks like. But I think, notwithstanding the fact that yes, it will create additional challenges of evidencing that, we do see some merits in it. I'm going to come in. No, nothing really to add. I don't think.
Okay, just then, just moving on, and just from yourselves and your own experience over the years, do you feel, or what maybe cases do you feel that sentences have been unduly lenient? Now, I've highlighted a few previously, the Public Prosecution Service. There's a general perception that there's unduly lenient sentences, and it's a lot to do with whether it's drug supply, attacks, whatever. It's on the most vulnerable, those that are isolated in their homes, those that have a mental health issue, those that have a disability, those that live on their own. Is there any specific offences that you have noticed probably over the last few years that this occurs most frequently in relation to unduly sentences based on the cases that you bring forward?
I would have to come back to you on that one. I wouldn't want to just give my own opinion on it. I would need to consult with sort of colleagues across crime department, for example, who would investigate serious crime that would go into the Crown Court, just to see if there was any particular themes emerging from that. I mean, maybe not necessarily in the Crown Court space, but I think there has been an articulation and a belief, certainly from the Federation's perspective, around sentences for the likes of assault on police, and there is a perception across the organisation that that could potentially be strengthened, but I think there is an acceptance of that across the Public Prosecution Service, and we've met with them and the judiciary around that. So that's probably one example, which probably doesn't even fit into this piece, because obviously this is a very kind of tight subsection of offences. But I would probably need to come back to you on that in terms of this specific piece around unduly lenient sentences, insofar as this bill is concerned, if that's okay.
Yes, no, that's fine, and that would be good. And just one final one then, just in relation to the new aggravators that are proposed in the bill. Do you see much system changes that would be required by the police to be able to record the new aggravators? And is there any additional training that would be required to assist officers to identify the aggravators and ensure the best evidence is secured to assist in potential prosecutions?
Yeah, so there will be additional training required. There's no doubt about that, and that will involve the whole organisation as well. So obviously, in around 10,000 people would need to potentially train around the changes that this bill would bring. We don't necessarily have a training plan around that yet, clearly, but obviously we'll be able to provide sort of further detail around what that looks like, the time and the cost, as we go forward. In terms of there will be system changes, because at the minute, and again, Paddy can come in here, but we do flag hate-motivated offences, for example, as per current practice. But I think it's just about understanding the exact difference that will come about as this bill, where there is a statutory aggravator, and how that is flagged, and how different that will be required to be from our existing practice. So I've no doubt there will be changes to our systems and processes from an IT perspective. Paddy, I don't know anything.
Yeah, no, I agree. We will have to have a look once I suppose this reaches royal assent. We'll have to have a look at the specifics around what the aggravation kind of looks like in terms of the protected characteristics, because at the present time we record by virtue of perception, whereas this will be a statutory foot and that'll be evidence led. So there is going to have to be some thought around how we actually record that internally, and that will potentially require some system changes.
Okay, well, thank you.
Thanks, Ciara. So at this point, it just falls on me to thank you all for attending the committee and welcome you to take your ease. Members, the next item on our agenda is agenda item number 6, and you'll find an annual performance report from AccessNI, and that's a Department of Justice written paper. You'll find that between pages 51 and 79 of your meeting pack. I want to draw members' attention to a number of key points in the report, including that almost 190,000 applications were received during the reporting year, the highest level of applications on record. A total of 8,474 certificates were issued containing disclosed criminal history information. 2 of the Minister's 6 targets were not met. 6 individuals barred from working with children and adults were identified as having applied to work with vulnerable groups, and the cost of operating AccessNI was fully met through fee income, with full cost recovery resulting in a surplus of £271,000. Are members content to note the paper or require any further clarification? No, and then Sasta. Brilliant. Can we then move to agenda item 12, which is in the tabled pack? So you'll find this item covered in pages 19 to 57 of the table pack. The Department has advised that a call for views to support the development of a new long-term strategy to reduce offending and reoffending will be issued today. The Department is seeking views on matters relating to understanding, offending, reoffending and harm, preventing first-time offending, reducing reoffending, reducing harm, structure, measuring success and delivering change. Are members content to note the paper? Do you want to consider further when the outcome of the call for views is available, or is any other further clarification information required at this time? No, everybody's content. Brilliant. Agenda item number 7, which is correspondence. You'll find the correspondence memo and 10 items of correspondence at pages 81 to 179 in the meeting pack, and a further memo with 3 items at pages 8 to 18 of the table pack. I want to draw your attention to 2 items, and then if any members have anything particularly they want to raise, they can do. Pages 101 to 121 of the meeting pack, you'll find 7.6, which contains correspondence from the Committee for Agriculture, Environment and Rural Affairs requesting views on the Areas with Natural Constraints Payment Bill. Can I seek members' agreement to provide a nil response to the ERA Committee? Sassy, yeah. And then 7.7, which is at page 122 of the meeting pack. This is a response from the Commissioner Designate for Victims of Crime in relation to recent correspondence to the Committee from an individual in post-separation economic abuse, and whether the matters raised by the individual will be considered by the cross-departmental task and finish group established by the Commissioner. I want to inform you that the Commissioner has advised that the task and finish group is focused specifically on the design of a pilot private law family court model for child contact and residence cases where domestic abuse is a feature. Its remit is therefore limited to matters relating to the operation of the family court, particularly in respect of child safety and participation. Can I seek your agreement therefore to forward the response from the Commissioner Designate and the original correspondence to the Department for further consideration and a response to the issues raised? Everybody's happy? Is there anything else that people want to raise, or are members content to note the rest of the correspondence memo?
I think I've got one, Chair. I'm just trying to find it. It's the one. I don't know what number it is. Sorry, it's 7.2. Will we ask for information from the Chief Constable about the gold mining with the Information Commissioner, and they give us a bit of an answer saying, look, we've done what we've done. We've given them the information to the Information Commissioner. You're not getting it. Are we allowed to write to the Information Commissioner to request that information?
Thank you for your letter. I'll take advice from the clerk there.
I would need to take advice on that myself. I would expect, because it's legal advice and it went to a court, that even if we went to the Information Commissioner, they would likely say no as well.
We can get advice
because
on
of
that.
it, but I can seek advice on that and come back to the committee.
I mean, if we thought it was worthy to write to ask for the information, so we understood it, then it's worthwhile following it up. And if we come to a dead end, we come to a dead end, and that'll leave it to members of the public to be able to do it through freedom of information, I suppose. I'm not asking Wales to do that, but we may as well ask the question.
Happy with that? Everybody's happy with that? Okay, happy days. So then we've got agenda item number 8, which is our forward work programme. And I want to refer members to the latest draft of the committee's forward work programme, found at pages 181 to 192 of the meeting pack. So we discussed last week a number of additional meetings have been scheduled for Tuesday mornings in September, October to facilitate the oral evidence sessions on the sentencing bill. Are members content to schedule additional meetings on 22nd of September, 29th of September and the 6th of October, which will allow the committee team to make the necessary arrangements for the oral evidence sessions?
Yep. What days are they, sorry, Chair? Tuesdays?
Mornings,
yeah. And what was the time? Was that?
9:30.
It's a bit in advance, so we're sort of agreeing to stuff. So just probably at that.
Sorry,
go ahead.
Those dates again. Tuesday, 22nd of September.
29th of September and the 6th of October.
And at 9:30 each day.
At 9:30, yeah.
That tight come down the M2 with the traffic to get here for 9:30, but I shall try.
Yeah. Same here. We'll both be late, Morris, more than likely. I also wanted, and I know we had a conversation about this at last week's committee. I know there was reference to Jasmine's Law having requested to present to the committee, and I think there was a rationale given that the particular issue there was kind of outside the scope of the sentencing bill. I wondered if members how they would feel about, because I know obviously Ciara and I think Mark Durkin have been in correspondence with Pauline Duddy, and probably all other members have had representations from her. If people would be happy, just that it does relate to tougher sentences, and we're hearing from other family members on sentencing. Are people content that we do schedule a?
I'm content,
Yeah. Would that be
For
okay?
formal evidence or
Yeah.
an informal meeting? So
Yeah.
to bring Ms. Studdy to the committee? And
Yeah, would that be okay?
Yeah.
And then, as well as that, I think the Equality Coalition had advised that they would be happy to present to the committee. I wonder if we could schedule an evidence session with them as well.
On the sentencing bill?
Yeah.
Aye.
Are members content?
Yep.
Okay. Is everyone happy with that?
Can I check on that? I have a joint committee meeting in my diary for the 30th of June.
Is that to be
For
reasonable
9
to
to
that?
next.
I don't think I have it.
Oh,
but-
that's
oh
the
sorry, Bruno, I
updated
do.
one? Yeah.
So we were supposed to have a joint meeting. It must be on that date. This is maybe worded differently. I don't know if you.
Yeah.
So the final stage of the inquiry and redress screen bill is scheduled for 30th June, as is the second stage of the Victims and Witnesses of Crime bill. At the meeting yesterday, the Committee for the Executive Office agreed to defer the concurrent meeting scheduled with this committee for that morning in view of the plenary business for that day. So the meeting may instead be scheduled for a suitable date after summer recess. Are members content with that?
Mm-hmm.
Yeah.
So take that out of my diary?
Yeah.
Grant.
Agenda item 9 is chairperson's business. I don't have any other business. Is agenda item 10. Does anyone have anything? No. So the next meeting is Thursday the 25th of June at 2 p.m. in this room. Okay. Is that us logged out?
If that was through now, we'd be here for another another hour here.
Committee Room 30. Sound. 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 Committee Room 30, 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 sound. Committee Room 30. 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 Sound.